for the opportunity of coming together to discuss the Indian Arts and Crafts Act and the procedures for writing the regulations for the Act. I think that we have some experts with us today who are going to be able to give directions and share their expertise with you in matters that are very important to each and every one of us. Our council, as well as the other sponsors of this seminar, are very interested in the Native American artists in our state. We feel we have the best Native American artists in North America living in Oklahoma. We are concerned about the marketplace for those artists, and we are concerned about their ability to create their art and also to stay in Oklahoma and have their families here and their life work here in our state. We held a seminar in January, and we heard at that time not only representatives from Washington, D.C., but also many of you in this room who expressed concerns about the legislation. After the Indian Sovereignty Symposium, we were asked to help sponsor this seminar and the one that will take place in Tulsa next week. I want at this time to introduce those speakers who are going to share with you today. And I would like to start by asking Connie Hart, who is President-elect of the American Indian Bar Association, to stand and be recognized. Thank you for that. Arvo Nakinen, who is an attorney with Andrews Davis Law Firm, is the president of the Oklahoma Indian Bar Association and the American Indian Bar Association. Arvo. I am not sure Sharon Blackwell has come in yet, so we will introduce Sharon at a later time. Dr. Leonard Strickland, Director of the American Indian Policy Center and Professor of Law at the University of Oklahoma. And before I introduce him to me, I would like to ask Nathan Hart, who is the Director of the Oklahoma Indian Affairs Commission, to come up and make some remarks.
I'd like to welcome everybody. Good morning to all of you who are here this morning. I'm very pleased with the group that has done a lot of work in putting together the seminar here today, and some of the previous seminars that have been held back in January. We had a section on the Indian Arts and Crafts Act at the Sovereignty Symposium. I think as we look back as to how the Act was developed, how it evolved, it's quite noticeable that not had very much input from Oklahoma people who actually did the writing of the Act, did not consult with us here in Oklahoma to see what some of the concerns of such legislation would be from our standpoint here in the state. So we're pleased that we can work together with the people that we have that are quite knowledgeable about legislative acts, rulemaking, and how the regulations are developed. I think what the focus of the seminar today is how we, as people here in Oklahoma that are concerned with the Act, how we can have input into how the regulations are developed. Because there is a need for some of the regulations to clarify parts of the Act, and we will go over that, concerns will go over some of these issues later on this morning. But again, I want to welcome everybody here, and I look forward to listening to our presenters.
I'd like to present at this time a man with whom I'm sure you are all familiar, a man who is an independent champion, not only of Native American art, but is not only internationally acclaimed and recognized for his art, but he is a prominent member of the Oklahoma legislature. And I'm very pleased at this time to present our friend, Senator Enoch Kelly.
Thank you very much. I want to extend, on behalf of the state of Oklahoma, welcome to each of you who are here to address the issue that you're dealing with today. Of course, my interest is more than casual or passing, because as an artist, I look at legislation as a gallery. I certainly have to look at the legislation as well. So I have an understanding interest in this particular area, and also being in the legislature, having some idea about the process. I have always contended, as Nathan indicated, that the Oklahoma tribes and artists in Oklahoma should have been consulted with before the law went into effect, and perhaps we could alleviate some of the problems we've had with this, the understanding of the new law. I want to thank all of the sponsors who have put this session together. I do want to say to you that this state capitol belongs to you. That this is the second such meeting we've had in the state capitol. When the law was first enacted and we learned about it, as you recall, we had a meeting in the state capitol. We tried to understand what the law was, and that was passed. So we've done that. As we begin to move to the second stage, as I recall at that meeting, there was a great interest in making sure that the Oklahoma voice was heard during the rule-making of the enacted law. At this point, as I see it, the law is enacted. The second part is that the Indian Arts and Crafts Board has been authorized to come up with the rules and regulations by which this law will be implemented and monitored. And we are at that stage. Now, whether you like the law, don't like the law, I don't think that's the question. I think what we're dealing with is the authority that is given to the Arts and Crafts Boards to develop the rules and regulations as it relates to the implementation of the Indian Arts and Crafts Act. At this point, you do have an opportunity for input. While there are a number of people here, and I'm pleased to see all the people here, I had hoped that those who had questions and will have questions about the rules and regulations later could have been here to add input, because this is your opportunity to express your thinking about the law. It is important that we have your input, because as I look at it across the group, I see artists, people who are in the gallery business, people who are in business to sell art, and other people who have an interest in this area. And it is important that this committee have your input as they develop these rules and regulations. I would assume that the third thing is that these rules and regulations have been developed and the draft has been made, that you would get a copy of the draft for final review and for recommendations or comments from you. Having said that, then the laws, years ago when I served in the House of Representatives, I recall not quite understanding how whenever laws were made about Indian tribes, I kept breaking them. And it was on this very floor that I learned that if you make the law, you can change it. And that's one of the things I contended, that section of the law or treaties that says as long as the waters flow and the sun shines and the waters flow and all that, and the grass is green, I contend that somewhere in the body of that treaty there's some statement, a small statement that says 30 days, whichever comes first. Now this is just to say to you that laws are not passed very easy, but they can be changed. And I don't know if there's address it, I do have to work in the meeting. But I think the thing that concerns me, Dr. about the task that you're doing is the definition of what Indian art products are in arts and crafts. That scares me a lot because I'm not so sure. I've been in the art business for years, and that's what I do. And we have not found in my opinion, in our philosophical debates, hundreds of hours of discussions throughout years, I don't know that we've ever come up with a clear definition of what art is. Maybe each individual has one idea, but to put into rules and regulations what Indian art might be, I think it's going to be very difficult. If that is the task, and if that's what conviction comes up, then obviously this group needs to address that issue. Having said that, I want to welcome you to the State Capitol. The sponsors of this conference, please feel free. And in the future, if you need to address the issue more, please let us know. We're more than happy to try to accommodate you. Thank you very much.
Good morning, I'm Mark, President Elect of the Oklahoma Evening Bar Association. And I believe that most of what I'm going to talk about this morning, those of you that attended the January session as well as the session at Indian Sovereignty have probably heard this spiel of the act. What I'm going to talk about is the legislative history. I hope not to be too repetitious, but it is very important to understand the intent that Congress had for a certain enactment. In this particular case, in 1984, the Department of Commerce did a study and learned that approximately $400 to $800 million annually were spent on Indian arts and crafts. Excuse me. Of that amount, $40 million to $80 million was estimated to be siphoned off from counterfeit productions of Indian art and crafts. Now, the part that was recognized in the act is that most of the jewelry that was undersold was Zuni, Hopi, and Navajo jewelry. It is also interesting that the regulations, as they existed, dealt with those tribes' jewelry productions, as well as Alaskan, Eskimo, and Alaskan Indian arts and crafts. There is a definition in the old regs that defines what that style of jewelry or that style of arts and crafts are. And part of it is that it's handmade, that there are no commercial products or I would say fake, like synthetic materials that are part of the final product. Now, whether or not that type of definition will extend into this new act is something that you as artisans or craftsmen need to have involvement in that definition. In your packet of materials are two reports. Now these reports there's part one, which was from the Committee on Interior and Insular Affairs, which first reported back to Congress on their revisions of the bill. And then the second report is the Committee of the Judiciary, which made their report. I believe it was the last report, and then it was this version of the bill that was enacted. Now, the legislative history, as published in USCAN, the United States Code of Congressional and Administrative News, which is where most people go to look to determine what the legislative history is. The part that talking about the definition of an Indian, comes from Part 1. The original definition for an Indian was a member of an Indian tribe or an individual certified by a tribe to give that tribe's lineage. Now, after the Committee on Insular Affairs presented that to Congress and the Committee of Judiciary got hold of it, that language changed to just to be certified by an Indian tribe. So there's a question that whether or not you can be certified by someone who is, or by a tribe that you have no lineal heritage to, it's probably somewhat persuasive that the original language is in the use scan, because that does show congressional intent that it would be that you would have some blood lineage, but you cannot do that because then you have an equal protection problem, because then you're looking at a race. And I will let Dr. Strickland talk more about that since he is a scholar. But being an Indian legally, and this act talks about the legal status of an Indian. It is a legal status, and Congress has allowed tribes to determine who is or who is not an Indian. Thus, if a tribe under this act decides not to certify individuals as artisans, that is up to the tribe to decide. The tribe can decide who is or is not a member. The tribe can decide whether they want to or whether they do not want to certify a person as an Indian artisan. The powers of the board were basically expanded under the act. The big purpose was to give the board a little bit more power to go after those persons who were basically illegally counterfeiting jewelry or other Indian style art and selling it as Indian art. The old act, when it was originally passed, was probably fairly modern for its time. But as criminal law changed, it became very hard to find someone willful, and the revisions in this act made it a little bit more modern so that the language in the act is similar to that of other civil actions as well as criminal actions in the big realm of federal criminal law. One area that is not discussed in the act and is the definition of an Indian product. I think that when we get to Sharon's part, whether or not she is here, we will give you information on how to become involved in that regulation process. The other change that occurred from version 1 or from one of the initial drafts to the drafts that the committees looked at was that Indian group was changed to an Indian Arts and Crafts organization. The reason for that was because when you register a trademark or register with the patent office, you need to register in a name or a name that you own, such as a corporation or an organization, a partnership. And the Commerce Department felt that Indian group was a little bit vague, and that there may not be an ownership of the name, so that there was that change. The other thing that I want to point out about the Act is that both sections, the criminal and the civil sections that have the definitions for Indian, Indian tribe, Indian organizations, they have a severability clause. And that clause has legal significance in the sense that should there be a lawsuit at any particular time and that the court declares one particular section to be unconstitutional, the rest of the act does not fail because of the severability clause. So even if, for some reason, the definition of Indian is attacked because it is vague or because of an equal protection violation, the rest of the act does not fail because of that one particular clause. I think I've covered most of the things I wanted to cover just as a background on legislative history. I believe Arvo's section really deals with a lot of specific problems with the act that have been identified previously and that we have looked at and discussed with other attorneys and kind of played around with. So I'd like to give Arvo a little bit more time, and the session that we will have after we all do our presentations, the open forum, that is when you can either ask us individual questions or just general questions, and Mr. Strickland will then let us address the question.
One of the things in coming up with regulations, first of all, you need to be able to understand what the act is. Purpose in most federal laws, when they are passed, you have the original law which is passed. And the original law, the interpretation of the original law that's passed must be done by looking at the legislative history. So these things have been very difficult to find. Most individuals in the public usually do not have access to this kind of information. That's one of the reasons that we put these provisions in your packets. Most individuals, when laws are passed, do not realize what went on during the debates. Normally, the first time an individual will ever see a law is when the law comes out. Usually by that time it's too late. And one thing that I know is very common with Indian people and tribal people is usually we're at the point where the law has already been made, we have no choice, we have no input as to what the outcome will be. Usually we react rather than get involved in an active way in the development of the law. It's important to have an understanding or have these materials because this gives you the background, this gives you the intent, the thoughts of the individuals in the House of Representatives when the law was passed. The reason that's important, you say, well, the law's already passed, there's nothing we can do about it now. The thing that you need to understand is once the law is passed, that is a broad general outline. It is an outline of what the intent of Congress was in regulating this area of basically misrepresentation. It's up to the agency after that time to pass the regulations which further clarify, provide procedures, provide specifics. There's a lot of things that are not specific in this portion of the Act. And I know that a lot of people wanted to have input. A lot of people didn't understand why the Act was passed in the first place. And don't understand why there was no chance for Indian people to have input into the Act. The reason we had this program today is because at this point you do have input. You will have input through the regulation process. We'll get into the specifics of how the regulations are developed, but we could, the alternative would be for Indian people to wait a year, wait 6 months, not have any input, not contact the Indian Arts and Crafts Board, not send in comments, not raise issues, such as some of the issues we'll identify here, and then in 6 months or a year, the regulations will come out. And at that point, unless Indian people have an input, I imagine that we'll have another forum, and then we'll have the situation where we'll be going over the regulations, and people will say, well, why did the Indian Arts and Crafts Board do this, and why didn't they consult us, and why did these things happen? We didn't want that to occur, and that's the reason that we had this session today, specifically to advise you, to give you the tools that you need in order to have an input in the development of the regulations. So the tools you need are the Act itself, which you had, the legislative history. The legislative history is important because that will give you an argument, such as some of the issues in Congress, an argument. For example, it's unclear under the Act, can the Comanche tribe certify a Navajo as a Comanche artist? Can the Cherokee tribe certify a Creek as a Cherokee artist? It's not clear under the Act. Now, certainly, a lot of those issues should be clarified in the regulations. And if you have a particular view one way or the other, you can use the arguments that Congress had originally dealt with to support your position. We're not here today to advocate one position or the other. We're not here to say that the Act is good, or that only federally recognized tribes should be included in the Act, or that state tribes should be out, or that Indians should be a certain blood degree. We're not concerned with that. That's a decision that should be made by all the individual citizens of the United States contacting the representatives. In this case, it would be contacting the Indian Arts and Crafts Board. So in order to have an understanding of what the regulations will be, you must have an understanding of the Act. If you don't understand the Act, then some of the regulations will probably not be enacted. One thing that you need to keep in mind with regard to these type of regulations is that regulations cannot alter the Act. Okay, you can't come back with a regulation and change something in the Act, completely change it. That's not something that is possible. If the regulation is in conflict with the Act, it probably will not be passed in the first place, or somebody can challenge it at a later time very easily to say that the regulation in effect overruled the Act. So that's one thing to keep in mind when you think about some of these regulations. The second thing that you need to keep in mind is that once the regulations are published, it is very important. The original, what they'll probably do is publish draft regulations. Those will be published in the Federal Register, and I'm getting a little bit ahead of myself here. It will be very important to comment on those regulations when that time period occurs, so I want you to keep that in mind. One thing that I've noted, I think, how many people have actually read the Act here? Actually read it, line by line, gone through the whole thing? Okay, I think about half of you. Actually, that's a little bit better than most times we ask that question. Many people have not read the Act, have not specifically looked at it. There have been articles in the newspaper that have said Indian artists can sue one another, and that you can have one Indian artist put another Indian artist out of business by suing them and finding that their art is not Indian art. People have raised the question that you can't have Indian in the name of legality. People have raised the question that nobody can sell paint pictures of Indians. If they paint pictures of Indians or Indian scenes, and that's Indian art, unless they're Indian, they can't do that. Arisen because, and I don't think any of those statements are correct, a lot of the confusion has arisen because a lot of people have not specifically looked at the Act. I think a lot of the early publicity about the Act was not as accurate as it could be. So what I'm going to do fairly quickly is run through the specific provisions of the Act. Because if you don't understand the Act, it's going to be pointless to make recommendations about the regulations. You need to understand the Act in order to understand what needs to be addressed in the regulations. Now, the second part that I would like to talk about is, I think, something that a lot of people have forgotten. And it is part of the regulation or the other part of the law that's unclear right now. And that is the question of tribal certification. How is certification to be done? I've heard stories of people who try to get certified, who try to get a letter from a friend on the business committee or the tribal council for saying, well, I've known so-and-so for so many years, and he paints really nice paintings, and I know he's Indian. He's an Indian artist as far as I'm concerned. He's right on like something like that. I know some of the tribal judges have an approach concerning certified Indian artists. So the second part that I would like to talk about, that's part of the regulation process as well. It's not really the federal regulations, but it's the tribal law. It's one thing that we thought we could do for the artisans, provide a model code or statute that the tribes could adopt. I know that some of the tribes are starting to do this. I think the Seminole tribe, we don't have, unfortunately, a copy of whatever their law is. But a procedure by which, and I'm going to run through that, that'll be the second part of what I'm going to discuss this morning. Run through the procedure by which an individual can be certified. And of course, it's to protect, it's not only to protect the tribe, but also to protect the individual. So you don't have one group, this could be a very political process, you don't have one group who likes a particular artist and certifies them, and then we have an election, and then the next group comes in and uncertifies the artist, and it goes back and forth like that. That would be a terrible situation. I'm sure that could occur if there weren't proper procedures in place. So that's the reason we included that. Okay, first, all of us know the Indian, as defined under the Act, is a member of a federally or state recognized tribe. Of course, we've said, what's that? I can't hear you. Somebody asked me a question? Okay. Okay, the Indian, under the provisions of the Act, is either a federally or state recognized tribe member. And of course, the tribe has a list of who its members are. We refer to the term equal protection. What does that mean? That is a provision of the United States Constitution, which means that you cannot discriminate against people based on their race. The concern was that you could not have an Indian defined as somebody who was a descendant or had based on racial grounds. You said, oh, well, somebody's so much Indian blood, therefore we should certify them as an Indian artist. You cannot do that. If you did that, then that would be a racial discrimination. You'd be discriminating on the basis of race. Supreme Court cases have said tribal membership is not racial discrimination because you can be, it's a political citizenship character which is connected with tribal membership. Because you can be racially Indian and not be a member of a tribe. For example, I'm Kiowa Comanche. I have enough Comanche blood to be enrolled as a Comanche, but I can't, number one, because I'm enrolled as a Kiowa, and number two, under the Comanche Constitution, your parent has to be enrolled as a member. My mother is enrolled in Kiowa, therefore, although I have enough blood, I cannot be enrolled as a Comanche. So it's important to realize that when we talk about equal protection, that's what we're talking about. You can't make distinctions on the basis of race. You can only make it on the basis of citizenship, political citizenship, which is the same thing as membership. Okay. And I'm going through this outline here. The certified Indian artisan. Okay, the certification, again, leaves the question of people who do not have a membership up to the tribe. The tribe can rely on whatever criteria it adopts. And I imagine different tribes will adopt different criteria. We'll get to the specific criteria in the artist certification model statute that we have here. Okay, Indian product. It doesn't say in the Act what an Indian product is. This is going to be very important when we get to the regulations. What is an Indian product? Okay, we can say beadwork, jewelry, necklaces. Now what about a jacket? I know that I think somebody had raised this issue at one of the seminars where somebody, I think it was, I believe it was Don Tate, who started selling embroidered jackets. Now, it's an embroidered jacket that's machine made, that has Indian designs. Is that an Indian product? We don't know. It doesn't. That's one thing that needs to be clarified in the regulations. And if you have a strong feeling one way or the other, that yes, everything that's ever made by an Indian, including pot holders and hot plates, beaded bingo dollars, and beaded coin purses and checkbook covers, and everything that's ever made by an Indian should be an Indian product, then right to the Indian Arts and Crafts Park say, I think all of these things should be included. If you don't, if you think it should, or you think painting should be excluded, or if you think certain types of ceremonial things should be excluded, like the Indian Arts and Crafts Board say, these are the things that are Indian products. These are the things, I'm an Indian artist, these are the things that we're concerned about. Indian Arts and Crafts and Art Organization, again, that is not defined. People have raised the question, well, does it have to be owned by an Indian tribe? Well, it's not clear. Could you have one person who is the chairman of the board of an Indian Arts and Crafts Organization and a group of non-Indians? Would that be an Indian Arts and Crafts Organization? It's not clear. Must they be 51% enrolled tribal members? That's not clear. Must they be 51% certified Indian artisans? So however you feel on these, I mean, what do you think an Indian Arts and Crafts Organization should be? If you have an opinion about it, you should write the Arts and Crafts Board saying, we want only Indians on. Or no, we don't care. We want, as long as it's dedicated to Indian art, and there are people that are committed to Indian art, then that's perfectly fine to be an Indian Arts and Crafts Organization. Okay, turning over to the next page. This is an outline of the provisions of the Act. And this is very important to understand. Okay, there's two parts of the Act. First part is the criminal provision. We've heard people, and I think we've said it before in some of these presentations. It's been reported in some newspapers to say, well, an individual can sue somebody else if they sell an Indian product and they will get $5 million. And that's not correct. You have to understand there are two parts of the law. There's a criminal part and a civil part. The criminal part is criminal laws when you break a law and either the district attorney or the U.S. attorney or the tribal prosecutor comes after you. And it's basically the state against you. You violated the law of the state, the tribe, or the federal government. And you would be punished by either paying a fine or being put in jail. An individual cannot bring a criminal act. I cannot, if I see somebody speeding out in the parking lot as we leave the seminar, I cannot walk up to you and say, you were speeding and issue you a citation. That's only something you government will do. So that's this part, that's the part of the act that deals with the $5 million fine. So let's go through this line by line. Okay, the criminal act, in order to break the law, you cannot knowingly, you know, offer, which means here I'm going to sell it, display for sale, which means it's displayed in your display case at a powwow, it's displayed at your gallery, it's displayed at your museum, or sell any good. If you actually sell it, or out in the lobby, if somebody says, I've got some Indian art here, I've got a necklace that I picked up, here it is. Any of those things, if you do that knowingly offers to sell or display. You know, so if it's just laying out on your coffee table, I don't think when somebody comes to your house, I don't think you're knowingly offering it for sale. If you do that in a manner that falsely suggests, and this goes to the misrepresentation, that it's Indian produced. If you say, yes, this is a Cherokee basket, or yes, this is a Apache basket, yes, this is a piece of Iowa beaver. It's an Indian product, or it's a product of a particular Indian tribe, or Indian Arts and Crafts Organization. So if I say, this watch here has come from the Zuni Indian Arts and Crafts Cooperative, turquoise inlaid. I know it isn't because this is a watch that I picked up at the Albuquerque flea market. It cost $10. This band, which is Philippine or Japanese or Taiwanese turquoise. And that's why I wore it. If I had that and I would offer it to somebody, sell it, or offer it display for sale, it said either the Zuni or that it's Indian made, or Indian had produced it, then I would violate the law. Now, if I did that, the U.S. attorney wanted to prosecute me, or the trial prosecutor wanted to come after me, they could. Penalties. If I did this the first time, now this is not an automatic $250,000 fine. It's up to that amount. That's the maximum. It's an individual. If it was a non-individual, such as a gallery, a store, a corporation, of course, you can't put a corporation in jail. That's why the reason we have a fine. It's not more than $1 million fine. Subsequent violations, individual, not more than $1 million fine, 15-year prison term. Non-individual, not more than $5 million fine. Does anybody have any questions about that? Do you all have any questions as we go along? Please raise your hand. We're liable to move on to something else. Who can file a suit? Again, individuals cannot file a suit for criminal law. It has to be the U.S. Attorney General under this act. Complaints, you have a complaint, you know that somebody's doing something, there's some counterfeit things. I've seen it. I've been here in Oklahoma. You can go to places and you can see baskets from Nigeria and from Africa, Indian designed baskets. I'm sure you've all seen it before. Lodge complaints with the Indian Arts and Crafts Board. The board will refer the complaints to the U.S. Attorney General for prosecution. Okay, that's the civil part. Put that aside. Now the criminal part. Put that aside. Now the civil part. Civil actions are brought by one individual against another individual, or a corporation against another corporation. The state is not involved. Private is not involved. The federal government is not involved. Okay, the activity is prohibited. Again, we do not have in the civil section a knowingly requirement. If you, again, offer, display for sale, or sell any good in a manner falsely suggests it's Indian produced, Indian product, a product of a particular tribe. Now, if you have something that you haven't caught, you don't know what tribe it is, so you say, well, I'm not sure, it looks like acting pot, but acting. And you don't really know, and you sell it to somebody, and you find out, well, my gosh, it's not an acting pot, or it's actually a Laguna. You may have violated the act, so you have to be very careful about that. If you've done those things, then you can be sued. Okay, what do you get? If somebody sues an individual, you can get injunctive relief, which means basically that's not money damages. That's either a restraining order to stop them from selling it, or an injunction to prohibit further sales. Second part is damages. Now this is an unclear portion of the act. I haven't been able to. This is something that needs to be addressed. Treble damages, that means 3 times your proven damages. Well, what are your proven damages? That's not addressed in the act. Okay, say I did this, I offered this for sale to you. How have I damaged the Zuni Indian Arts and Crafts Cooperative? There are a number of different things that you may look at. If I'm a big company, how much have I cut into their market share? How many items did I sell? How long have I been doing it? It's not real clear what your damages are. How have I hurt the arts and crafts cooperative by selling? If I was a big company, I may have hurt them a great deal because I may have cut into their business. But that's not addressed in the act. If you have a strong feeling about that as an artist, saying that the damages should be any profits they receive by selling these things. You should tell the Indian Arts and Crafts Board. Or if it's based on how many goods they've sold and how long they've sold, you need to tell them that. Okay, that's the first alternative for damages. The second alternative bring suit, not less than $1,000 for each day on which the offer, the display for sale, or the sale continues. Well, it's not clear in the Act, continues from what time. I mean, you have to send somebody a notice and say, you're hereby notified that if you continue to sell these things, that, okay, the date's going to start running right now. Okay. I offered this watch for sale to you on August 2nd, and I get a notice from one of you tomorrow, August 3rd, and I sell it for another 10 days for display for sale. Is that the time period when it starts? When you're notifying me? Or does it go back to say, if I've been doing this for 10 years, does it go all the way back to the beginning of the 10-year period? That's not clear. That needs to be clarified. So that's one thing. Identified. Needs to be clarified. Punitive damages to punish the wrongdoer. That can be in addition to the actual damages. And also attorney's fee and cost of the suit. Now, you will notice under the Act, the U.S. attorney or a tribe are the only ones that can file suit. Again, I repeat, only the U.S. attorney or a tribe can file suit, a civil suit. They can do it on behalf of the tribe or a tribal member or an Indian Arts and Crafts organization. So you can't, as an individual, go down to the courthouse and file a suit. You have to convince the U.S. attorney to do what they have. And there's an additional requirement. It has to be requested by the Secretary of the Interior for the U.S. attorney to get involved. Or you can go to your tribe and convince, not your tribe, or maybe somebody else's tribe, convince the tribe to file a suit on you. The earlier versions of the Act, if you look through these, permitted any aggrieved individual. So if somebody just walked down the street and went to the local truck stop and tried to buy something and said, particularly Indian harm, they could have filed suit. But the way the Act is written now, that's not correct. That individual would have to go to any Indian tribe or U.S. attorney to try to convince them to file suit. Where does the money go? It goes to the Arts and Crafts organization, the Indian tribe, or the individual Indian on whose behalf the suit is brought. And out of that recovery, cost for attorney's fees and court costs will be deducted. Okay, there's another provision on Oklahoma state law. I'm not going to go into that explanation today. I don't want to take too much of our time. There is a state law. So you have a remedy under the federal law, you have a remedy under state law to bring a claim. Of course, the state law penalty is not very severe. $25, not less than $25, more than $20 penalty. Okay. There's some potential protective steps to comply with the provisions of the Act. Again, what we're telling you here is not to be construed as legal advice. We've said this before. I'm an attorney, and we have attorneys here. We're not giving you legal advice. And if you ask us, we'll say, no, we didn't. If you have any questions, make sure you consult an attorney because there are severe penalties involved. We don't want anyone to presume that they're acting correctly. In fact, it will vary on fact by fact situation. If you have a question, you want to know what to do. I know there are some things that are going on in the state where people are saying that somebody is slaughtered is Indian product of a non-enrolled tribe. I would certainly want to get some legal advice about doing it. Okay, if you're selling things, make sure don't rely on certificates of degree of Indian blood because again, we said Indian blood doesn't matter. It's tribal membership. Get tribal membership. If you buy things from traders, make sure that they're actually made by Indians. Don't rely on what somebody else says. Oh yeah, it's all Indian. If you're not sure, you don't know, put something on it, and some people refer to these as disclaimers. We might talk about that a little bit during the question and answer session. There's nothing inherently wrong with the disclaimer. That's actually to protect individuals legally and morally. People express problems with this. legally protect yourself. If you don't know, put not Indian made, not Indian produced, not produced by private member, or that long language that many of you saw at some of the different events. Very legalistic way of saying the same thing. Don't mark things again. If you don't know if it's a particular tribe, it looks like something that you don't really know, don't mark it as being a Cheyenne moccasins or whatever it is. Don't mix in your items. Don't, half of your things can be Indian made, half of them not. Because the question will ultimately, if somebody sues you, the tribe sues you, it will be up to a jury. And the jury will determine, well, would a reasonable person believe that if you had a table of everything was Indian made, we said all, 100 out of the 99 out of 100 items were Indian made, and there was that one item that wasn't, and they purchased that item, they could make a persuasive argument to the jury, say, well, everything else is Indian made, I thought it all. So you have to be, it's going to be determined by a jury or a court. So you have to think about how they would determine this. Any question?
What court would this be?
Well, that's another unclear question. Some of the regs refer to federal, state, or tribal court. It probably would determine where it happened. Now, this is a federal law, so I think that as far as the criminal procedures, probably there was earlier supervisions in there for state district attorneys filing suit. That was the lead, so I would, it's not real clear, but I would think, any other comments that any of the speakers had might elaborate on that, but I would think in the criminal act, they would probably be a federal court. The U.S. Attorney is definitely a federal court. Now, tribe, I don't know if the tribal prosecutor would bring a claim based on this act. It's not a tribal act, but a tribal prosecutor would be different from a tribal court. I think it probably would be difficult because it's not a tribal act, it's a federal act. Civil suits, that's the real question. Probably where the sale occurred. It occurred on within Indian country. Although it's a federal act, you might have a civil claim to the tribal court. Again, it's a question whether or not the tribal court applies federal law or whether or not they recognize it. You always have a claim for fraud or misrepresentation. I mean, that's always been out there. It's not anything different because of this act. And in the state, it happened in the state jurisdiction. I still probably think it would be probably, I don't think there was a specific provision providing for federal jurisdiction. There is?
No,
I don't think there is.
but since the Attorney General of the United States can bring both the civil and the criminal action, you're looking
I
at
think they probably would consider that one could file suit with that. That's another item. Raise this with our where do we file suit? Okay, again, make sure Indian art certifications are valid. Rely on letter of the artist's favorite committee or private council members. Gosh, I've known Joe since day one. As far as I'm concerned, he's Indian, and I like his art. He's Indian artist as far as Make sure it's an official.
I'm sorry, we cannot hear you.
You can't hear me? Okay. I think we've got the hammering going on. What I just said is on the certification, if you don't make sure that the official body is doing the certification, don't rely upon a letter. Make sure that it's whichever body in the tribe has authority to certify. And we'll get to that with the certification statute, because that, if the tribe adopts something like that, then you know, because I've seen it happen in tribes again, to dispute, okay, can the business committee certify something? Somebody would say, no, in the Constitution it says the business committee can only do certain things, and that it would have to be a vote of the entire tribal council, which in some tribes is the entire tribe. Then I've heard also some people say, well, what about the tribal legislature? It depends on how the tribe is set up. Whoever has the authority to certify somebody, I think probably the best thing to look who's the body that has the authority to certify a tribal member? I think it's kind of the same thing. You know, that you can't get a letter from somebody on the business committee that makes somebody a member. It just won't fly. So you need to be careful about relying on what people present to you if you're a gallery or an artist. Okay, we made a list of questions. We identified something. You have, I'm sure, certain questions that you think need to be clarified. We've identified some additional questions just to give you some ideas. And I'll just run through them very quickly. Questions have arisen. How are deceased artist works to be treated? It's not clear in the regulations. On the one hand, you could argue that, okay, if the deceased artist was an enrolled member, that they should be determined to be an Indian. However, you may be on the other side and say, well, if they weren't enrolled, can the tribe come back after the fact and certify somebody who's already passed away as an Indian artist? Question. We don't know. If you feel, yes, the tribe can certify anybody they want. Now that's a question probably that should be addressed to the tribe rather than the board. But you may want to try to have the board get involved in that process. They may put some limits on what tribes can do in the certification process. Personally, I don't think that that's a good idea. I think that the tribes are the ones that should make the decision about tribal membership. And now that's just my own personal opinion. I don't want to impose my personal opinion on you. But generally, it's the tribes. It's the tribes' membership. The tribes should determine who their members are. It should determine who is certified and what you have to rely on to be certified rather than the federal. But everyone has their own view. How will Canadian or Mexican Indian works be treated? I think it's clear that they're not included on the Act. Maybe good to clarify and have some regulations that address that, especially in the border areas. Where should suit be filed? Somebody raised this question. That's something that needs to be addressed. How does one treat a product partially made by an Indian person? I had a question one time. Somebody said, well, I made medallions, and they're Indian medallions, but somebody else, a non-Indian lady, makes the buckskin dresses, and we put it together. What do we have?
I used to buy an awful lot of things from Crees in Canada, some beadwork, and a lot of their crafts that were made out of wood items. And you passed by that a little fast for me. I wondered, how should those Canadian Indians be treated in this?
I think as long as you have a comment on
Yeah, in your packet you have a fact sheet from the Department of Interior Indian Arts and Crafts Board, and on page 5 they kind of talk about that. They say that the Act does not really apply to Canadian groups or Mexican groups or South American groups, but that the best thing to do to comply with the Act is to label the country of origin. So you can say this is Canadian made and
Well, we did that just anyway.
yeah.
But that would probably be the same thing. For example,
You might even be able to identify the group, like Canadian Creek, for example. Because as long as you have the country of origin, I think you're taking it out of the United States Indian product.
Okay.
At least that's what the Interior believes at this point.
okay, did everyone hear that? Basically, if you have something from a Canadian, for example, Creek. Now, this Canadian Creek crop, there's about 10 Creek crops or more. You want to label it Canadian Creek rather than just Creek, because somebody could think that was American Creek from Rocky Boys, Chippewa Creek, or something like that. That would be the safest thing to do. That way, it's kind of a truth in advertising. You want to be truthful with whoever the purchasers are. If you're not truthful, if you're not accurate and truthful, then that's what the Act is designed to punish. Okay, back to the product partially made. That's not clear under the Act. That's something that needs to be addressed in regulations. Do you think, as an individual Indian artist, or as a sold as an Indian product. I've heard stories of manufacturing plants where basically there's all on Indians involved, and the Indian at the very end of the assembly line will just polish it up a little bit, and then it goes out and the tribal member who made it. That needs to be addressed. Okay, is assembly alone? Item 5, again, this is another question that has come up. Okay, if you put things together, if the Indian is the only person who just takes the stone and everything else is shipped in from Taiwan, and you got an Indian person who puts a piece of plastic stone in the hot metal ring, is that an Indian-made product? Not clear. When do the damages start to begin accumulating in the civil section? Okay, that was the issue I raised. It says the act says as long as the sale continues. It continues from what time, what day? Okay, must an individual possess Indian blood in order to be certified by an Indian tribe? That's not addressed in the act. It doesn't say, there's nothing about the certification. I want to make a strong argument. I think that's, again, a decision to be made by the tribe. Some tribes have adopted people who are not have any Indian blood. Some tribes have adopted people from other tribes. And that's very common. A lot of times, especially with the Indian Child Welfare Act, where a lot of Indian children are being raised by Indians, but they're not that particular tribe. Okay, 8, will the Arts and Crafts Board keep any official register of persons? That's a question. Do the tribes need to notify, send to the Arts and Crafts Board, okay, these people have been registered? What items will be included in the definition of Indian products? We touched on that. May a tribe decide not to have a certification procedure? That's not good. Does the tribe have to have a certification? The tribe said, well, gosh, we don't want to certify anybody. 11, may an artist who's an enrolled tribal member of one tribe get certified as an Indian artist by another tribe? For example, if you had somebody who was, who was Quapaw and Shawnee, and was an enrolled Shawnee, but really had lived all his life with the Quapaws, or her life. Can the Quapaw tribe certify the enrolled Shawnee person, even though they could mark their artist Shawnee as Quapaw? That's not clear in the act. Again, 12, may non-Indian be certified? Address that question. Okay, 13, we touched on this. What is the definition of an Indian Arts and Crafts organization? Must it be totally Indian-owned? And remember that the Indian Arts and Crafts organization can file suit. Composed of all Indian members, must it be simply majority Indian-owned, or composed of majority Indians? And how again do we define Indians? Okay, 14, can state-recognized Indian tribes certify persons who claim to have blood from another tribe, or have no tribal blood at all? The only distinction there is the state-recognized tribes. Some people raise concerns about state-recognized tribes certifying people. 15, which they can do under the Act. 15, can a certification of an Indian artisan be revoked by the tribe after it's granted? So you have one day somebody's in, and the next day another administration comes in and says, well, gosh, we don't like this person, let's revoke their certification. We don't think that their art is really, we need to stay away from that. That's a danger. That's one reason we have this code here, so we don't get the tribe passing on quality of art. So, gosh, that doesn't look like traditional kickapoo style of art. We're going to not certify that person. And again, if the tribe refuses to grant certification, what, if anything, can the applicant do? 17, can a tribe that has been terminated certify the artist? I don't think that's specifically addressed. Probably they can, but for example, the Klamath tribe has been terminated, and they now come back and know they're not a tribal government certified artist. 18, can a person who's a member of a terminated tribe obtain certification as an Indian artist by another, if another tribe cannot certify him as an Indian artist? So if you have somebody from New Klamath. If the rule were to come out and say it was a full-blood Klamath Indian and that tribe was terminated, and as a result of that, there is no tribal government, is that person out of luck, or can, say, the Colville tribe certify somebody who's Klamath as being a Klamath Indian artist? I doubt if it was a Klamath Indian artist, perhaps Colville. Okay. Again, what type of criteria may the tribe examine? 20, how are damages to be calculated? In the civil claim, not so much the time period, but how are the damages to be calculated? And are manufactured items subject to the act? I think we touched on that question. And I see that Sharon Blackwell has gone, so I will go through this model certification statute. A lot of people have said the other main empty part of the act at this point in time is not just the regulations, but the certification procedure. Because tribes, from the day that the act was passed, it is law now, tribes can now certify individuals as Indian artists. The question is, how are they to do that? This is a draft, a rough draft of one possible way that just, and we provided this to you. If you want to go to your tribe to try to get the tribe to adopt some type of procedure, unless they've already done it themselves, you might start with this. A lot of this will not apply to all tribes. Different tribes have different types of government. Some have legislatures with vetoes by the chairman, some have business committees, some have a lot of different types of act. But this is something you can start off with. Section 1 is just the title of the act. Section 2, the purpose of the act is to certify somebody as an Indian artist in the provisions of the act. Section 3, this is, I want you to understand, this is not federal law. This is something for the tribe to adopt, either in a resolution. However, this will be a tribal law. Definition of all of the terms, nation or tribe, shall be whatever nation it is. There's a blank there. Member is, however that tribe defines its members. Indian blood means the blood of any federally recognized tribe. Now, you may want to have in your tribe recognized state. I don't know if you're doing it. Federal Act means the Indian Arts and Crafts Act. The applicant means a person applying to be certified by the nation. Now, secretary, tribal secretary means secretary of the nation. The governing body, and I just use that term because it's not clear in each tribe who's going to be the one to make this decision. Is it the enrollment committee? Is it the business committee? Is it the tribal council? Is it the chairman? It'll vary by tribe. So we officially designate the tribe adopts this procedure. Who is going to be the one to determine whether or not an artist is certified? The Act will do this. The governing body shall mean the business committee or the tribal council, or whoever it is, which is officially designated as a division of the tribal government which has sole and exclusive authority to determine certification. Okay, Indian artist certification shall mean the document, and I contemplate that some tribe will have an official document or something that somebody can possess, so they can show it, it shows, and they can prove it, and provide it to galleries or whoever wants to see it. Some proof, it's like a tribal enrollment card or a CDID or a letter certifying your Indian blood. So there should be some document of certification. Tribal court, we have a provision in here for an appeal to the tribal court. I don't know if the business committee or the tribal council will like that. That's basically to protect people's rights. We included that in the provision. The enrollment office, we contemplated that the enrollment office would be the most logical place for keeping track of all the people who have been certified by the tribe. Because they keep track of the tribal membership rolls in most cases, in most tribes. They would be familiar with the procedures and keep it official. Instead of calling it a roll, we call it a roster of Indian artisans. Okay. Section 4 is the criteria for consideration. These are some thoughts that I had. Of course, any tribe can adopt whatever they'd like to. These are some of the things they may like to look at. The applicants, lineal ancestors, if any of his lineal ancestors were members of whatever nation it was. 2, the applicant's degree of Indian blood, they may look at that. They may look at the applicant's degree of Indian blood from another tribe. They may look at his or her place of birth, his or her place of residence since birth, his or her current residence. The tribe may look at the applicant's knowledge of language, customs, and traditions of the tribe. They may look at ties, bonds, relationships with members of the tribe. They may look at marriage to or blood ties to other members of the tribe. They may look at membership or participation in tribal societies or clans or ceremonial groups or other things like that. Basically, anything that that particular tribe has. 11, applicant's membership and participation in tribal religious practices. They may look at the applicant's membership or participation in if there are any tribal artist guilds, Indian arts and crafts organizations, tribal arts and crafts organizations. They may look at formal or informal adoption into the tribe. So those are some of the factors the tribe may look at. I think if you were an artist or somebody trying to get something like this passed by your tribal council or business committee, you'd want to try to keep away from getting to the question of the tribal council passing on their art, whether or not they like the art or not. I don't think that's proper. Yes.
Do you know of any tribe that considers these?
No.
7, 8, 9.
And are you suggesting possibly that a tribe could just consider one or all of these?
They can consider one or all of them, but they can add things to this list. These are just thoughts.
Right. Well, I understood that, yeah.
These are just different things that logically one could look at in some type of proof. Yes.
If someone in the audience has a question, if they will stand, we'll turn on the microphone, and as soon as they stand, they can just pick up the microphone at your desk. That way you can hear.
Okay. If you do have a question, you can use the microphone. That way everyone can hear the microphone.
okay.
So apparently they will be turned on.
Yeah, okay.
Okay. Question? I think. The answer to the question is, can a tribe have to do all these things or any one? It's up entirely up to the tribe. You can think of other things. I'm sure the tribes will think of other things. These are just a possibility. I'm going to go ahead and wrap up pretty soon because we're going to take a break. We may come back to some of these items. We have Section B, evidence supporting the application. Whatever factors you have, you don't want to have vague factors that somebody can't figure, can't document. Provide a provision in here where somebody can attach documentation, birth records, death certificates, religious records, those kind of things, to their application. And the way that we've structured it is the burden of proving that they're a certain artisan is on the applicant. They have to prove it. Now, the tribe can adopt a different burden if it wants to. But the way we've adopted it is kind of civil. Many of you watch the People's Court that say you have to prove your case by a preponderance of the evidence. It means you have to tip the scales one way or the other. Application procedure. And there should be a form. Any person wishing to be certified has to fill out a form. We include a provision where they have to swear that the information is true and correct. And to keep track of these things, we thought that the tribal secretary, now maybe somebody else, maybe an enrollment clerk, but the form should be given to the secretary of the tribe, delivered and stamped on a certain day, postage either delivered or mailed. Remember, the federal act said we cannot charge for certification. So we included that provision that the Indian tribe in Section 5C cannot charge for certifying somebody. We can't have a tribe going into business certifying. Some little tribe somewhere on a tiny reservation decides to go into business and certifying people and creates a market for Indian artists to be certified. You cannot do it. At least for money. Okay, we give a requirement that the secretary has to forward the application to the governing body within 10 days. These are some deadlines so that we won't have something filed and just sit in the basket somewhere. It will not be addressed by the governing body, and the governing body has to consider it within 120 days. If they don't, you go to section F, and that's kind of a penalty that they're automatically certified, so they can't sit on something for a long period of time the way this is structured. If they don't act within 120 days, they're automatically certified. It's kind of a penal provision. And section G provides for an optional hearing. If the governing body wants to have a hearing, which they may want to hear from some of these people who signed affidavits, we provided that as an option. We're not required to give a hearing, although if the governing body wants to have a hearing, they can have one. But you must give notice to the applicant. You can't require 30 days written notice so that you won't have a situation, somebody out of state gets notice the day before it occurs. You can't get it. These are a lot of procedural things just to protect everyone's rights. The decision, in section 8, if it's denied, they must state why it's denied. They can base it on information presented in the application, gather that the hearing or the tribe has other information, enrollment records, and say, oh gosh, all these people who said they're Indian really aren't Indian or don't have the blood that they say they do. The tribe can rely on those records. If they deny it, they have to say why. This will be a permanent record kept. If they grant it, again, they must say why, what written form, what they based it upon, and that's made a permanent record. A copy of the decision in both cases mailed to the applicant. If somebody has been approved, the enrollment office is to keep a roster of Indian artisans so everyone will know if you have a gallery calling up and saying, well, is so-and-so an Indian artisan, and then that way there's an official roster of the enrollment office that say yes they are or no they aren't. Okay, with J, we've got a restriction on the removal of an Indian artisan, and that prevents somebody from being removed unless there's a signed affidavit from a tribal member who says that when they were originally certified, they got it through fraud, misrepresentation, false records or information, or incorrect information. They must have supporting facts and documentation, specifically what it is that was fraudulent, specifically what it is that is apparently incorrect. And that's to protect individuals from having their certification removed without the proper procedure, or at least a chance for them to challenge it. K is the removal procedure. A sworn affidavit, which is filed for more than one. The tribal secretary, the applicant has to be notified that their certification is being challenged. A notice which goes to them that describes why they're being challenged. Section 3, the individual is permitted to introduce additional evidence to support their certification, and they have a hearing to present additional information. After the hearing is concluded, the governing body can either decide to cancel their registration if they find out there was some kind of fraud or incorrect information, or they can keep that person certified. And they again have to state in written form why they make the decision, what they rely on. And if they're dissatisfied with either somebody who was not certified to begin with or who was removed, they can appeal it to the tribal court. All federal court, state courts, local courts are prohibited from determining it. The way we've structured this is just to go to tribal court. Appeal has to be made in writing. Any sovereign immunity of the tribe is waived only to permit either enrollment or non-enrollment, so that an individual cannot sue a tribe for damages if they say that they were certified by one group and then the tribe removed them and they did damage to their reputation and that kind of thing. That's not permitted under the way we structure it. The tribal court has jurisdiction to review the decision that was made by the governing body, whatever governing body it was, and the only way they can overturn it is if there was if it was arbitrary, capricious, or completely lacking factual or evidentiary support. That means the tribal governing body made a decision that was just completely not supported by anything that was in the record. The court is to presume that whatever the governing body did was correct. correct, and that the individual challenging whatever the governing body did has the burden of proof of showing that these mistakes occurred. The court can hold any hearings, and appeal through the tribal court for such a procedure. I think our next, on our agenda, our next section is a break. We will resume. Unless you have any questions, you can save those at the end, and we'll be around. Take a break for about 15 minutes, and then we'll hear on the specifics of the rulemaking process, what you specifically need to know, how the rules are making process is completed, procedures that will be provided by Sharon Blackwell, who's Assistant Regional Solicitor for Indian Affairs. Right in front here, Sharon, you might stand just for a minute, identify yourself. After our short break, we'll resume with Sharon.
Federal Register on Thursday, July 25th, 1995. Only large libraries subscribe to the Federal Register. The law library that is closest to you will have one. The University of Oklahoma, University of Tulsa Law School, Oklahoma City University, and beyond that, University of Arkansas will subscribe to the Federal Register. Many government agencies have subscriptions to the Federal Register, and so you may want to check. I'm not sure whether, I don't believe the BIA agency offices have the Federal Register. I know that the BIA area offices subscribe to the Federal Register. The Honorable Mechanism has advised me that the Oklahoma Indian Bar Association will be watching the register and will notify the State Arts Council when the proposed rules are being published, and will make copies of the proposed rules available to the State Arts Council. And so I suspect that Betty Price will let you know as well. At any rate, the proposed rule will look as the one that you have in your hand. It will give a brief summary of the proposed regulations. The important thing, of course, today is always, it will invite comments, public comments across the nation, and there will be a time frame that will be set, generally 60 to 90 days. Generally 60 to 90 days to comment on proposed regulations. There is a place that tells you where to send your comments. There will be a name and a commercial telephone number for the person in the agency, that person in the Department of the Interior that is responsible for the promulgation of these regulations. That is very valuable to have a person's name. You want to pay close attention to that person's name. So seldom does the Department of the Interior give you a name. And then finally, if there is any other information that you need to review before you comment, there will be a place that will give you supplementary information. I urge you to make a comment. If you like something in the regulations, comment on it. Chances are someone in Alaska will not like that provision and so you need your comment there in front of the Department of the Interior as well. I need to tell you that Oklahoma, as I'm sure you're well aware, is a state that in which jurisdictional issues are still being handed down from courts at every level in Oklahoma today. Federal courts are deciding issues of Indian jurisdiction and Indian sovereignty issues. 3 federal courts in the state of Oklahoma. We have CFR court, we have tribal courts, and we have the state Supreme Court and state court of appeals that are handing down decisions concerning Indian jurisdiction. It may behoove you as an Oklahoma Indian to comment upon that special status that Oklahoma Indians have in terms of tribal jurisdiction, CFR court jurisdiction, federal jurisdiction, state jurisdiction. You may want to comment on that as well. This is your opportunity to put your views in front of the Department of the Interior. We are back to number 7 on the list. When the public comment period has ended. The board, the Indian Arts and Crafts Board, will analyze the comments and then they will revise the proposed rule where appropriate. That does happen. It does happen that the proposed rules do get revised. It's a little seldom, but it does happen. Again, they go back for circulation through the Department of the Interior because there have been changes made. And so everyone that looked at them the first time has an opportunity to look at them again. Comments, again, OMB, once again, reviews them, makes their revisions, and then approves the proposed final rule. The final rule then is published in the Federal Register, once again, in a publication like this, as a final rule. Thereafter, it has, as I said, it has force of federal law. The final rule publication will show a summary of all of your comments. The Department of the Interior is duty-bound to either respond to you personally or to mention your comment within the summary of comments in the Federal Register. And then it becomes effective 30 days after the publication. It's 30 days notice, and then it becomes effective as, again, as with the force and effect of federal law. It's very easy to miss these things. This is something that you really have to mark the times. If this act affects you, if you've read the act, you've heard the discussion today, and you are concerned about the vagueness of the statute, then I encourage you to at least send your suggestions. Arvo mentioned earlier there are some issues that we can predict will probably not be addressed in the statute, in the regulations. That should not prevent you from discussing them in your comments. There are some, in the handout that Arvo has prepared, on the final page, the list of questions that might be clarified through the promulgation of the regulations. And our time does not permit us to go through and discuss those. There has been some discussion of many of those issues beforehand. I'm sure our folks touched on them in review this outline. Yes. Okay, thanks. I have been in and out of the room and didn't hear whether there was the possibility that meetings would be held throughout the country again, or as it was before the act was passed. There were two hearings, one in Washington and one in Santa Fe, I believe. And Congressman Campbell had told me that when those meetings took place, that one might happen in Oklahoma. And I'm wondering if I missed that, or if there is some place here where that might take place in this list that makes a difference.
Those public hearings are not necessarily recorded as a matter of procedural due process. However, where there is a lot of interest and where people request public hearing, then certainly the Department of the Interior will signal that to the Congress. I would also encourage those of you that are interested in having public hearings to write to your congressman and to request that hearings be held in Oklahoma. And I think that is something that, regardless of how diverse your interests may be, certainly that would send a real strong signal to the Department of the Interior to consider these regulations. They will have to consider those comments that are made in the hearing.
I'll embarrass Sharon. Sharon is the mother of the groom at a wedding this evening and came from Tulsa to be with us. Either that is a sign she wanted to be away from it all, or that she has a real commitment to these issues, or perhaps a combination of both of those. This is a section that is known and listed on your program for comments. And the people who have been on our panel this morning are going to be available also to respond to questions during this period of time. Before we began, Connie Hart asked me if I would point it out, because it's a wonderful illustration of the kinds of regulations that you can end up with, the nature of it, the kinds of regulations that we have under the Indian Arts and Crafts Board. For example, dealing with Navajo, Pueblo, Hopi silver, and turquoise products, and the standards. There are 2.5, 3, 4 pages in 25 CFR in little print that lists the kind of detailed regulations that can be produced in this process. At the same time, we often have regulations that are so broad that we spend what those of us in lawyering call full employment for lawyers acts. Those bills and regulations that are so uncertain and so unclear that they have to be in court all of the time, and that not even a lawyer can figure out what the answers to these things are. So at this time, I want to open the discussion. This gentleman is the microphone specialist, and he'll give you the opportunity to speak into the microphone. And we welcome either questions or comments, testimonials, revelations, observations on the act or the questions raised by it.
I just have one comment. Okay. I just have one comment. I think a lot of the issues that we've identified probably will not all be addressed in the regulations. I think we probably need to stress that. A lot of these issues, I think, ultimately may, as Professor Strickland has indicated, end up being determined not just through the regulation process, but also through court proceedings, if there are any court proceedings that are held in connection with this, and also with the tribal councils. I think some of the issues, particularly dealing with certification and things that are probably outside of the scope of what the Arts and Crafts Board wants to deal with, will not be addressed in the regulations. So don't be surprised if you comment about a lot of different things that don't appear in the regulations. Although, nonetheless, I think it's to the Arts and Crafts Board's interest to hear what everyone's comments are, not only about the regulations, but just the act in general, because people have mentioned possible amendments of the act. If you were to comment to the Arts and Crafts Board, they would have a readily available body of information on all aspects of the act. So that may, in the future, if it's ever, the act is ever amended or brought up again, that way the Arts and Crafts Board will have a lot of knowledge about how people feel about the act. So don't be surprised if the regs come out, there's a lot of these things aren't addressed. I'm sure that people, some of them are probably outside of the scope of what they can address, and they may want to stay away from some issues that probably should be decided by the tribes. Nonetheless, they are unclear issues that probably need to be addressed either by tribes if it's dealing with certification, or perhaps a further amendment of the act at a later time. So that's just kind of a look into the future of what may ultimately be published in the Federal Register. I just want to clarify that point for everyone.
two-part question. When the regulations are enacted, will these regulations be contrary to the express will of the tribal people, or will the views of the tribal people be given paramount will? And the next one is, will the regulations be so clearly written as to ensure a minimal amount of litigation by non-tribal people who claim to be of Indian descent? We don't want a person's Indian identity to depend upon how expensive an attorney that they can get.
Let me try to answer the second one first.
Okay.
Which was whether the regulations will be written in a way that is so clear that the determination of the outcome will not be dependent upon the deep pocket of the alleged Indian and their ability to litigate the question. I guess the answer to that is hopefully they will be written in as clear a manner as possible, and that the procedures for appeal, and that I think part of the answer to this rests with what Arvo did with regard to the construction of tribal certification and those issues, because the question of actual membership, it seems to me, is something that has a relatively easily discernible answer, and that your controversy and litigation is going to be over the certification. And if the process of certification is not so well founded and written in its original nature that it can withstand those kinds of tests that Arvo raised, for example, equal protection, then it will be a long-term matter of who can litigate forever. The way the Act, though, and I think the regs, the person who is claiming to have a certifiable degree of Indian persona does not acquire that until a certificate has been issued. So it is not an advantage of the person to prolong the litigation. The first one, which was, to what extent will the interests, concerns of tribal people be reflected in the regulations? And I think part of that is the extent to which tribal people make their views known to the Indian Arts and Crafts Board. A number of you were at the session at the Supreme Court Sovereignty Symposium, at which one of the members of the Indian Arts and Crafts Board, Rick Dene, was present. And I think that was the point that he made. And it is the making of regulation is in fact a political process in a very real way. And you remember the old line of Oscar Wilde's that you didn't want to see sausage or legislation being made. Well, it may apply to regulations as well, but much of it will depend on the extent to which tribal people make their views known. And if you look, as Sharon suggested, at the list of the people who are on the Indian Arts and Crafts Board, I think there are people there who will listen to tribal viewpoints.
I said it was two-part.
Okay.
That's my line. How many commissioners are on the Indian Arts and Crafts Board, and is there a vacancy at present?
I'm sorry, the noise of the...
How many commissioners are on the Indian Arts and Crafts Board, and is there a vacancy or vacancies at this time?
I don't know. I think there are 5. I don't know whether there is a vacancy or not. Sharon?
There are 5, and I know of no vacancy there.
Okay.
But from day to day, as you know in state government, there may be vacancies that you never expected.
There may be after this regulation process begins because they serve without compensation.
Thank you.
I was just looking at the 1935 Act, and it authorized the board to be composed of 5 commissioners. And looking at this, the commissioners are on a staggered term and are appointed for a term of 4 years. And then unless there is a vacancy, then someone is appointed to fill that vacancy for the remainder of the term. So I suppose if it is not listed in here as to when they were appointed to the board, just you could write and ask, but then just calculate 4 years, and I would assume that each year, it looks like each year or every 2 years, there would naturally be a vacancy. Thank you.
I wonder if you might address the recent movement by some of the art galleries and museums to define Indian art as an Indian style rather than as an outgrowth of tribalism, and if the act might address that, or the rulemaking process.
Well, let me put on my art critic toupee and take off my lawyer hat. And I think one of the impacts of the act quite clearly will be to separate and redefine in terms of art galleries, museums, the nature of Indian subject matter versus Indian made. And this, of course, has the original Arts and Crafts Act, and as Connie suggested in her original discussion, much of this dealt with Indian craft art, as opposed to, God knows what the difference in definition is, Indian fine art. I think much of the difficulty with where you go on this looks at art forms like easel art, painting, sculpture, which are, or at least in terms of painting, in its easel art form, nothing that in that form is something that an Indian artist of 300 or 400 years, or 500 years, or 600 years ago would have been engaged in. But yeah, I think in the long run, we're going to see an extension of what has already been happening. And I've spent, Ed Wade is hiding sort of midway back. We spent a lot of time in the early 80s with some exhibitions at Philbrook and other places that looked at evolution of art by Indians, and hosted a number of conferences at which Indian painters were saying, we wish to be judged as painters, quote, i.e. not Indian. And for a lot of people, I think it's going to give them that wish.
A lot of the shows require that you be a quarter or more right now. I see more developing across the nation. How will a letter of certification affect these shows? The other questions I have are products that are assembled. You will incorporate a lot of things in paintings or in sculpture or in prints that are not Indian made, and yet when an artist uses these products, does that constitute then Indian art or Indian made? The other question is art that is produced, does it have to have a specific tribal affiliation or origin, or can you incorporate other tribal aspects?
But Humboldt, who was one of the great, Humboldt and Llewellyn, who were great scholars in the 1930s, said that Indians were the first warriors, whether they knew it or not. The first question was, to what extent will the act impact on blood quantum requirements? And my sense is that there's nothing in the act that addresses the blood quantum issue, and that is a separate issue that shows may choose or not choose to follow, and that isn't something that the amendments to the Indian Arts and Crafts Act took on as doing. It may have a secondary impact if the tribes in their process of certification tie certification to a blood quantum. But beyond that, I don't think the two in any way are going to overlap. The second question of incorporation is, of course, a wonderful lawyer-like question. There's some law students who are here today, and in law school, we construct on our exams those kinds of questions. And I can just see an Indian law exam that would describe an Amundsen painting, for example, that was a painted oil canvas with a bucket attached and a duck decoy and 6 strips of beadwork, all of which were Taiwanese. And in my art critic toupee, let me suggest that I would classify that as a work of Indian art. And I would classify it as a work of Indian art because it is a painting, and the incorporation of those products into it were part of the artistic impulse of an Indian. Then I get and I picked the beadwork for the reason that we have now left the painting and we have gone, and it would take 7 pieces of beadwork to do a belt for me. And we have some hand cured, cleaned dough skin to which the 7 strips of Taiwanese beadwork had been applied. I think I would not classify that as an Indian art product, unless the description of the beadwork's origin were there. And these, of course, as I said, are the sort of head of the pen and the number of Indians that can dance there questions. And I'm sure that's not a clear answer, because there isn't a clear answer. And I don't think the Indian Arts and Crafts Board is going to adopt this time the kind of very specific language, as Waikami pointed this out, because it has things like applique elements in the design. All such parts of the ornament are to be handmade. If wire is used, it is to be handmade, with no tool other than a handmade draw plate. These requirements apply to the boxes for stone used in the design. So if one goes to that level in definition, it's going to be bigger than Sharon's proposed 600-page public, and the crucial thing, which in the final analysis is what is behind all of this kind of legislation, and that is to prevent fraud, to keep purchasers of art from being sold something that is different than what they think they are buying. It's really an equity question, as Arvo suggested. It is something that at its most basic level is covered by common law and statutory commercial regulations. And your last part of it, the Shawnee who paints or does sue beadwork. That was the question you were asking about. I do not believe that there's anything in the Act that is designed to so restrict the artistic freedom of an artist in his or his evolution. I think we have a two-step question that is taking place here. And the first of these is this person either a tribal member or a certified person by a tribe? And once that threshold has been questioned, has been crossed, that's a yes or no. There is nothing in the Act that goes beyond that to the question of the nature of the artistic judgment that is made about whether this person wishes to do baskets in the style of the Chemawavi, or to introduce, and a lot of this is tied to the concept, which is awfully strong in the art world, that there is some moment of pure Indianness, and that is either in 1842 or 1867 or 1927 or 1939, and that you take a photograph at that moment, and that the art that is produced at that moment is pure and correct and Indian, and that which comes later isn't. So I go on and on. My students tell me I take it, because they're good at this.
I would like to comment on the provision that allows for certification of a state or federally recognized Indian tribe, and specifically the state recognized tribes. A lot of the tribes here in Oklahoma and elsewhere are having a lot of difficulty with the state recognition process. I'll give you an example. I have discussed it with several members of the 5 tribes in the tribal council. Got an edible band of Cherokee Indians in Tennessee that's recognized by the state. Now you see these guys at these rendezvous stores, you know, dressed in furs, you know, but they're white people. They like to be hanging around Indians, hanging around the fort guys, you know. But they're they file a petition for the Bureau to go through this BIA recognition process. Once they file that, then they feel that they have the right to go ahead and certify themselves as Indian artists. And this Act kind of allows for that. And they're popping up all over the place. Georgia, Alabama, North Carolina, and other areas, Texas. They all seem to be Cherokees for some reason, you know, or Taino. But there's a group of Seminoles that participate as Seminole artists, and these people are really taken away
authority of the tribe to designate and recognize and determine its own membership. I really am opposed to this provision that allows for state-recognized Indians to certify themselves, sort of like regulate themselves in arts, particularly when we're having trouble here with Indians that come up with this case of my father was on the road when I was the Indians. We have a couple of pretty famous cases here in Oklahoma. And I'm really disturbed about a letter that went out under the pen of the 5 Tribes Intertribal Council, Griffin, that hinted, that she wrote letters all across the country that they were not satisfied with this act, and really criticized it, and kind of hinted at the fact that all Indians in Oklahoma felt that way. I'll read you very quickly. Today, only a little over 5 months after its enactment, Senator Bourne has advised us that efforts to repeal never came to them. This Intertribal Council Museum, this 5 Tribes Museum. And to me, it kind of bypassed an important body right there. And I want people to know that this isn't endorsed by Indian people. And I really think that, in my opinion, that maybe we ought to stop buying Griffin jams and stop watching Channel 9 to let these people know that we won't be dictated to by philanthropists who like to have Indians around, like to have Indian art on their walls. I don't like them circumventing the law by coming up with this egghead or naghead or what is that, NGED they call it, non-governmental descendant. To create a class of Indians. In my opinion, only God can do that. Only the Creator can make a Cherokee or Seminole, but these guys think they can, circumventing the law by creating the non-governmental no descendant. Now she boasts that the Gilchrist Museum has already started doing that. That indicated that the Red Earth Committee has kind of gone along with that. And to me, that's circumventing the law. We fought hard to get this law, and as we all know as Indians, they don't always do what's right for us in Congress. We have to go back and change it. If she has problems with it, let her go through the process like we all do. But don't write to Bourne and Nichols in our Oklahoma delegation and tell them this is the way Indians feel, because it isn't. And I think we as Indians should stand up and say, wait a minute, who do you speak for? Wait a minute. If you feel that way, why don't you find another museum to hang around? Because Indians should determine the policy of Indians museums. Indians should be on those boards. We got a museum down in Woke, Oklahoma, Seminole Nation Museum, all white. Every one of them. And my family has mentioned their ability to create beautiful art. I'm really opposed to this, what I consider as an undermining of the governmental process of determining our own membership. And I would like, when you develop those regulations, to seriously consider dropping that state-recognized Indian from those provisions, because they are exporting that provision, creating a new class of Indians that have nothing to do with those trees, have nothing to do with their culture. I met these people. They don't speak their languages, and they don't do any of their customs. And I went to a couple of their powwows. Those are hilarious powwows that have been over there in the southeast and the east. And I go to powwows around here in Oklahoma. And when these artists set up at these powwows, we get too many of our powwow communities that are more anxious to take the booth fee than they are to check their credentials. And by being there, they hint that they're Indian. And these are the people that should have those disclaimers on there. I've only been to one powwow, one booth that had this is not an Indian made product. Only one powwow, all the powwows we have in Oklahoma, only one that I see one trader do that. And I think more of these laws, they should be somehow controlled or policed, or at least we as Indians, when we have our own powwows anyway. We should be sure that we stick to the law. We should be sure when these are not Indian made that we insist that they put these disclaimers on them. We should insist on that. It doesn't cost us any money. If we lose a few dollars in booth fees, we could always find other Indians that are willing to take it up. Because I know very good Indian artists in my own tribe, Seminole, that are starving right now, while some of these other more aggressive non-Indian artists that produce Indian, look like Indian art, are getting wealthy. And to me, that, as much as the law was created to stop a lot of commercialization, the mass production of the cast jewelry and so forth, to me, this is as much the point of the law as those large producers are, those individual artists. They get these, somebody got these states that you could go present an affidavit with 3 people on it that swear that you're Indian, or produce a picture of an old-looking woman, dark complected, and they'll give you a card saying that you're Indian. And this is what I think is a loophole that you could drive a truck through. I'd like to see that loophole close, Dr. Strickland. When you write those regulations, tighten that up. Make sure that there are Indians there, and Indians that are determined to be Indians by their tribes. Thank you.
Although, of course, one of the needs come up in the vendor. When I was in Florida, there were 7 Variant Creek tribes seeking state recognition there as well.
One thing that I just wanted to emphasize, that in the conversation that Sharon and I had with Jeffrey Stams, one of the things that he stated was that the certification process or criteria will probably not appear in the regulations because they tend to believe that that process, like membership, is left to the tribe. Now, what it's possible they may do, if enough people request it, is that they could write, these are some ideas of criteria, such as what Arvo spoke about in his sample certification process. Now, it's possible that you can have suggestions for criteria in the regs. The other thing that Arvo mentioned, and I didn't really spend that much time, the first act did not include state Indian tribes, state recognized Indian tribes. That came in by congressmen who had several state Indian tribes that they recognized, but that were not federally recognized. My brain has short-circuited. I cannot even tell you the locations, but I really believe that some of those states are like North Carolina, South Carolina, and Georgia, and a couple people that were left in, not to be funny, but in the woodwork when other people came out. Many of those tribes are in the process of seeking federal regulation. Now, whether they do or not receive that is another question. What I may propose to you in your comments and identifying the issues is tell the board that you think that even if they don't put in what certain criteria or ideas for criteria, one thing that they should put is that when there is a certification, that the certification should state the nature of the tribe that certified this person as an artisan. Is it the federally recognized Seminole tribe of Oklahoma? Is it the federally recognized Seminole tribe of Florida? Is it the Seminoles who say they're Seminoles and they're recognized in Tennessee? Now, I don't even know if there's anything like that, but that's an example. Because the more information that you have on the certification will educate or will inform the buyer. Now remember, this is a marketing act, or it's a truth in advertising act. So what they're doing is
you need to inform the person that's purchasing who made this. And so that may be one thing to distinguish the certain types of certification. And I think you made a very good point, because I think that there will be, there will be a tendency to have a lot of different tribes pop up that we never really knew about that could possibly get state recognition because they have a lot of political clout in certain states. Another point that I wanted to make rather quickly is that one of the things that Jeffrey Stams had stated that they might need help in is how to assist, or what are some suggestions that are available to truthfully describe a non-member who has Indian heritage. Now remember, that's race, Indian heritage as being the bloodline. How can a person with the race or the bloodline truthfully describe his art as being of that bloodline without misrepresenting that he has the legal status of an Indian? And the legal status of an Indian is that you're a member of a federally recognized tribe, and that the tribe can determine who their members are. Now that's a legal status. Need to keep the legal status as far as marketing, which is who this act protects, are those Indians that have the legal status, and different from the race. And I say that very cautiously. But those are a couple of things, and the board said that one of the things that they fought for in this act was for the certification. The board says they tend to be more inclusive rather than exclusive. They would rather include a larger group of people as opposed to, start stating that people are not Indian for one reason or another. So those are just a few comments that I wanted to make on that.
Okay, we'll take one more.
May I ask that if there is an individual artist who is truly of Indian descent, does not have certification, will this bill in some way, and in this bill some way, affects their livelihood, would the Supreme Court or courts rule on the constitutionality of this bill?
I think there's a real possibility that the question would reach the Supreme Court. And since, as we always say in the business, free advice is worth what you pay for it, my sense is that the court would in fact sustain this bill, because there are a series of cases in which they have sustained the membership question as a legal determination of who is an Indian. I'll take one more.
My question has to do with the labeling. I went on stage, and it goes back to what Mr. Haney said here. The burden of proof is being put on us as an artist to label it. We are Indian. I think it should be the other way around. When you go into a museum or into a store or to a powwow, this item that's made in Mexico or Canada should be labeled as such, and not put the burden of proof on me. I know who I am. I know I am certified under my own tribe, by provision within my tribe. But I feel that maybe this is something we need to, as Indian artists or Indian people, need to address, because I just don't think it's fair to have to put on a piece of artwork that I've done, whether it's a basket, a double wall basket with Kiowa paintings on it. I don't think that I need to do that under this act. And I was just wondering if the labeling this particular product as Indian made, do I have to do that, or should I just let that go in case I want to sell something else?
That really goes back even not to this act, but the original act, which was part of the New Deal effort to promote arts and crafts but the regs I don't think can be written in a way that would shift the burden. It would require an amendment to the act. Let me do just no minutes remaining. A plea that I think incorporates everything that was said today, and that is, let your views on this be known. There is a procedure outlined by which it can be done. And I know that the Oklahoma Arts Council and our congressional delegation and other individuals, including a commitment from the House staff as well as Rick Denay when he was here as a member of the Indian Arts and Crafts Board, that they will be back in Oklahoma to hear what we have to say. But I don't always trust what I hear, Sharon, out of either Washington or your office. And I wouldn't wait for them. I take it on myself to make my views known and make them known now. Thank you.
I want to again thank all of our speakers today. I think that the information that has been presented has been very, very helpful to us. I think that we have the opportunity now for those in this audience. We will have another meeting next week in Tulsa at the Greenwood Cultural Center, if any of you can join us there. And I think that this information now will be very helpful in helping us in Oklahoma play a part in the regulations for this. And I feel that we should have a meeting in Oklahoma, and if you are supportive of that, let us know, and we will try to see that we are heard on that. As I said, there was a verbal commitment for that, and I do know that there were some dollars attached to it. However, Sharon, it was if we get the money, and so that might be a reason not to have meetings outside of Washington, but we hope that that could happen. May I have a show of hands of people who feel that we should pursue having a hearing in Oklahoma on the regulations? Well, I think that appears to be almost everyone in the room, so we will certainly pursue that. Again, I want to thank our co-sponsors of this morning's seminar and our very excellent speakers.
No, I mean, not. This is our practice, right?